Welcome to War Room, the official podcast of the U.S. Army War College online journal, graciously supported by the Army War College Foundation. Please join the conversation at warroom.armywarcollege.edu. We hope you enjoy the program.
Make sure not to miss a single episode and subscribe to A Better Peace, the War Room podcast, on Spotify, Apple Podcasts, or wherever you listen to your favorite shows. The views expressed in this presentation are those of the speakers and do not necessarily reflect those of the U.S. Army War College, U.S. Army, or Department of Defense.
Welcome to A Better Peace, the War Room podcast. I'm Ron Granieri, professor of history in the Department of National Security and Strategy at the U.S. Army War College and podcast editor of the War Room. It's a pleasure to have you with us. A cynic once said that talking about war crimes is like handing out speeding tickets at the Indianapolis 500. That the very concept of trying to limit or regulate the conduct of war is itself a fool's errand. However, many thinkers have spent a lot of time thinking about, organizing the law of armed conflict. Students at the U.S. Army War College are encouraged, are taught, are required to understand the role that the laws of war play in campaign planning and campaign execution. But what are those laws? Who enforces them? Who makes them? And what are the practical realities of the law of armed conflict within international law? In order to address some of these questions today, A Better Peace is delighted to welcome Professor Alexandra Meise, who is an associate teaching professor at the Northeastern University School of Law, currently seconded to the U.S. Army War College as a visiting professor of National Security Studies and the U.S. Army War College's Chair of Women, Peace, and Security Studies. Professor Meise's career in private and public service, strengthening, promoting, and securing democratic governance and rule of law domestically and abroad, has spanned 5 continents. Her research on sovereignty and statecraft, national security, climate security, democratic participation, and human rights stands at the intersection of policy and public and private international law. She has been a colleague of mine in the Department of National Security and Strategy for over a year now, and I'm delighted that we finally got her here into the studio at A Better Peace. Welcome, Alexandra Meise.
Thank you so much. It is my pleasure to be here.
So, Xandra, I want to start with a very broad question. So, what do we mean when we say the law of armed conflict?
The law of armed conflict, which is also known as international humanitarian law, are the guideposts by which conflict happens. Mm-hmm. So as you mentioned, right, we issued these speeding tickets at the Indianapolis 500. But in fact, even the Indianapolis 500 has rules of how you drive across that track, when you can hit another car, et cetera. And that's what the law of armed conflict seeks to do. Mm-hmm. War is chaos and it is hell. But we can have some rules and regulations that we can follow in the conduct to make it as regimented as possible and hopefully minimize the impacts on non-combatants and on others that are engaged in the conflict.
So who makes the law of armed conflict?
This is a really interesting question. It comes from multiple sources. So often when people think about Loac, Law of Armed Conflict, or IHL, the International Humanitarian Law, people think of the prime Geneva Conventions, which came out of our Great World Wars. So those are treaties. Those are agreements passed between sovereign states. So each state that has signed on to one of those Geneva Conventions, one of those treaties, has agreed to that set of rules. It's a binding obligation to each other. But in addition, we have different states having their own internal regulations on what those treaties mean. They have their own implementing legislation on how they're going to apply it. So if we look at the United States, the UCMJ tells our service members how they should conduct their conduct. That might be more precise than what the Geneva Conventions say. We might also look at certain rules of engagement for a particular set of exercises that a country may issue to its service members as to what they can and cannot do. So you have this balance of an international system of formal agreements. You've got domestic law. Then you also have these other agreements, such as the Rome Statute to the International Criminal Court, which took the Geneva Conventions, took all kinds of international law and agreements that have come in the decades since, and articulated some definitions of things like war crimes, crimes against humanity, genocide, and offered an opportunity of a place for international accountability for the gravest breaches of these norms and laws.
And norms and laws. Well, and you get at, in your description of who makes these laws, you get at the question of who enforces them. And what is the balance between individual states deciding to enforce these laws on their own behavior and on their own combatants versus some kind of international organization? Or, so in other words, how do you punish somebody else for violations of the law of armed conflict if they don't want to punish their people?
So I will give you the classic War College answer of it depends.
Solid.
Accountability comes in many forms and in many ways. So first, you've got your state-to-state level accountability. So if we're talking about something that's a violation of a treaty, you've got options to, from a state standpoint, to bring another state to a tribunal to determine if that agreement of their treaty has been violated. So what's interesting about that is multiple parties, let's say, sign the Genocide Convention, okay? If one country is accused of violating the Genocide Convention with regard to its conduct against another country, those two countries, can have their own argument, bring their own case, let's say, before the International Court of Justice. But any country that's a party to the treaty can bring another country who's a party to the treaty to bear. Because the idea is that if you are violating this treaty against one of my fellow state parties, you're also violating it against me, because we all agreed we weren't going to violate that. So that's one method, the International Court of Justice. The International Court of Justice was created through the UN Charter. So this is a post-World War II creation. It is located in The Hague. The Hague is a city, so it's not synonymous. We like to use it. Oh, we're sending you to The Hague. We're gonna come back to that, I think, in a bit. But that's about state to state. You also have something called the International Criminal Court. Now, this was established through a treaty, which is known as the Rome Statute. States have signed on to be parties to that treaty. Actually, as of last month, I think there are 124 state parties to the Rome Statute. So well over half of our recognized states, but certainly not all. But that court has jurisdiction over, I mentioned before, crimes against humanity, war crimes, genocide, also in particular circumstances, which applies to fewer states, but the crime of aggression, they can prosecute against individuals. Okay, so while ICJ was state versus state, International Criminal Court can criminally prosecute individuals for these violations.
So when I'm thinking of historical examples, so when, say, Radovan Karadzic in Bosnia, was he brought before the International Criminal Court?
He was brought before the precursor to the International Criminal Court. So before we had an ICC, in the 1990s, the UN Security Council, through its authorities to preserve peace and promote security, created the ICTY, the International Criminal Tribunal for the former Yugoslavia, and the ICTR, the International Criminal Tribunal for Rwanda. Over time, there have been some other special tribunals created as well, but for purposes of this, I'll stick to those two. So those two created these ad hoc, these independent standing courts to investigate and prosecute crimes that had happened in those two locations. So those happened. There was a recognition of, wait, humans are flawed, shall we say. War will continue. And while, World War II may have seemed a long time ago, these two tribunals had great successes. There was a thought of, can we have a freestanding tribunal so that we do not have to keep coming back to the Security Council and asking every time? This is particularly, of course, potentially troublesome given we have 5 permanent members, the veto power. There's a lot of other things on Security Council's plate. Let's pull it out of what some call a political process into this independent freestanding court, which then has the resources, the expertise, et cetera, to independently prosecute. So that's how we get the ICC, which is a post-2000, comes into force.
And so the ICC, which is around now, that is where charges may be filed. So
Yes.
that is where, for example, charges were recently filed against or arrest warrants were recently put out for leaders of various states.
Yes. So this is where it gets really interesting, and I must express some frustration with the media over confusing some of this.
This is why we brought you on here.
I hope to be helpful. So the ICC is an independent entity from the United Nations, from the ICJ. Okay, freestanding. It operates with an office of the prosecutor. And the Office of the Prosecutor can investigate violations of the Rome Statute if it's within their jurisdiction. I can get to what that means in a second. But they can independently decide to investigate. A state can say, hey, can you come over here because I'd like you to look into something. Ukraine, for instance, has done that following 2014 invasion of Ukraine by Russia. Also, the UN Security Council can refer something for investigation. But this is for investigation, okay? The prosecutor holds the power and the authority to then investigate and then decide whether there is sufficient evidence for charges. Okay? So then we move to just because something is investigated doesn't mean we get to charges and a warrant for arrest. But right now, for example, ICC has been investigating an assortment of crimes since Russia invaded Ukraine in 2022. That has resulted so far, and I say so far because who knows what the future may bring, in charges against Putin, against one of the other top ministers in the Russian government, the person who's in charge of children's welfare. Okay, so there are warrants issued for those two individuals, and that's how that comes to be. So it is a process. I want to also note, though, I just talked about two international options. There are domestic options, too.
Good.
So when a state signs on to the Rome Statute, part of what they agree to is to enact domestic laws that allow that state to realize the purposes of intent of the Rome Statute. This includes having some kind of provision to prosecute war crimes, crimes against humanity, genocide, et cetera, domestically. Because one of the most important principles underlying not only the Rome Statute, but frankly, international law more generally, we've got the issue of state sovereignty. Yeah. And as each of these states made this firm commitment to give up a little piece of that sovereignty to let some other thing engage in criminal prosecutions, potentially against its own citizens, that's a very big deal. So it's all balanced onto something called the principle of complementarity. And what this means is that if you as a state, okay, have one of these heinous things happen either on your territory or by your nationals, you in first instance are supposed to investigate. And if that investigation then, find something, go through charges, warrants, a trial, et cetera, okay? If that process is engaged with domestically, the ICC is never supposed to get involved. The ICC was designed to be a court of last resort, either because domestically these crimes are being handled, or because in some instances we're looking at those most responsible for these most egregious things, the people at the top, the planners, okay? So the heads of state, the top ministers, whatnot, right? That might be something that is beyond the capability of the domestic entity to engage in. And there is this thought for these most heinous crimes, there is not immunity, for instance, for genocide. So that's, sometimes there's a concern in domestic courts if a sitting official might have some immunity. Let's just make it clear, just because you're the head of state doesn't mean you have immunity from something like genocide. So there's this domestic court option is supposed to be first instance.
Well, I'm fascinated. This actually cleared up something for me just now. So I don't know about the rest of you, but I just learned something about the relationship between domestic and the ICC. But if the ICC is the court of last resort, does the ICC have, or does it claim, any power of essentially appellate jurisdiction or judicial review? Can the ICC say, yeah, you guys claimed to put this person on trial, but we don't like the result? Can the ICC act?
So the short answer is yes.
All right.
But of course, it's a yes, but.
Yes, but, sure.
what the ICC would be looking for in that kind of instance is something truly arbitrary and capricious, right? So a process devoid of due process, a process that is very obviously perfunctory, okay? The ICC is very aware of its position relying upon the faith and promotion of states that are involved. It is not going to just willy-nilly reach in and start grabbing or attempting to grab jurisdiction over these cases.
Sure.
So, but I want to make clear, if a domestic process doesn't find enough evidence to prosecute, that doesn't immediately mean the ICC gets to step in, right? Because if, again, that process was reasonable, followed procedures, kind of fell in line with certain baseline standards, there's a deference to the domestic entity. But it's true and expected that there may be times when, of course, we've looked into the Minister of Defense's actions and have concluded that there is nothing here. Well, let's say that all happened in a 3-day period with, one memo and not any documentation. You could imagine a set of facts where ICC might say, but that would be an extreme set of circumstances.
What is the formal relationship of the United States to the International Criminal Court?
We are not a party. And if I may describe it this way, we are aggressively not a party because we were heavily involved in the negotiations of the Rome Statute. We signed the Rome Statute. So you don't sign something unless you intend to then ratify and join it. However, we then went through the rather unusual effort to unsign the statute following a 9/11. We actually, and it's funny but true, when you sign a treaty, there actually is a person who has the authority on behalf of a sovereign government to pick up a pen and sign a name to a piece of paper. And there is a place where all of these papers are held as the official repositories of these agreements. So we went through the effort of doing the formal documentation and paper trailing of unsigning.
So literally go find me that copy so I can scratch out my name?
Figuratively speaking. But yes, we went through all the formal processes and we unsigned it. So we are not a party. But we certainly have many of our allies and partners who are parties. There are several other countries, though, that are notably not parties. So the first two that come to mind would be Russia and China.
Yeah. And so as a result, not being a party to the ICC, then the ICC would have no actual jurisdiction over those countries or over a national from those countries or ...
This is where it gets messy.
Yes.
Okay. So there may be circumstances where people who are from a non-state party are engaging in actions and hostilities on the territory of a state party or against nationals of a state party. And now we start to get into a bit of an area where the ICC prosecutor may have jurisdiction. So there was some controversy, for instance, some years back about the ICC looking into actions of some of our soldiers in Afghanistan as part of operations they were doing there along with NATO. You also have circumstances where even if a state is not a party to the Rome Statute, they can ask the ICC to come in. So let's go back to the Russia-Ukraine example. Okay. Ukraine had not been a party to the Rome Statute. 2014 happens. The Ukraine asks the ICC, hey, we are now going to say you are allowed to look into things that have happened on our territory related to the Russian invasion. And that's not backwards looking, so it has to be from the time of consent forward. But that was then already in place before the 2022 then further incursion. And so Ukraine has already said, yes, you can come in. And that's why nearly immediately the ICC could start looking into what was occurring.
That's interesting. I understand, right? No ex post facto law, so you can't do it afterwards. Let's talk a minute about the crime of aggression.
Okay.
Because even in the International Military Tribunal in Nuremberg, right, one of the charges against the Nazi German leadership was that they plotted an aggressive war. And I guess this is where it gets kind of complicated, right? Does planning for war, is that prima facie evidence of aggression if war breaks out? Is the only side that is guilty of the crime of aggression the side that fires first? How does one determine who the aggressor is? Is there Is there a formal legal standard for the crime of aggression?
Is it cheating if I say it depends again?
That's all right. No, this people will understand what we do here in Carlisle. So go ahead. So what does it depend on? I guess I got to start asking the question that way. So what does it depend on?
So you're right, Ron, that the UN Charter following World War II, coming out of this, sort of Nuremberg approach, talks about we're going to protect against this proactive use of force. So Article 2.4 of the UN Charter says, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other matter inconsistent with the purpose of the United Nations. Okay, so that, if you think of that as sort of the grounding piece, okay? But to your point, well, does that mean we can never do something? No, because there is, of course, recognition that you can engage in self-defense.
Right.
Now, what is self-defense? At what point is the threat so imminent that it's okay to engage in self-defense, even if that means you fire the first shot? All of this is where we get into the depends.
I was just thinking, is armed deterrence a form of aggression?
Well, there is recognition that any analysis of the crime of aggression is very context-based, very context-specific. We're looking at scope. We're looking at facts, timing, temporal factors, all of this sorts of thing. The belief, of course, is that just having an army or preparing for war is not in itself a crime of aggression. Okay? To preserve the peace, we must prepare for war. This isn't accepted.
Last I checked, as we walk into this building every day to go to work.
Right. So that's okay. But what is prohibited, right, is for aggressive reasons, for one's own goals of achievement, invading the territory of another state where there is not a self-defense implication. Okay? So if we look at the crime of aggression then as articulated by the Rome Statute. And I have to take a hot minute here just to explain. So when the Rome Statute was first coming into force, the three buckets of crimes were genocide, crimes against humanity, war crimes. There was a recognition, though, at the time of that discussion that they needed to get to the crime of aggression, but the states didn't want to wait till they had figured that out before putting the rest in place. Okay? So fast forward, let's say about a decade, give or take. There is then a new conference where everyone comes to discuss that definition. So coming out of a 2010 conference in Kampala, there was, okay, we're going to define the crime of aggression. It sounds very similar to what the UN Charter says, okay, but with a few tweaks. So in that instance, it says, for the purpose of the statute, crime of aggression means the planning, preparation, initiation, or execution by a person, because, of course, the ICC is against people, not states, person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression, which by its character, gravity, or scale, and those are the three factors, right? Character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. So let's say, hypothetically, okay? Right. You send small special forces unit into another country's territory to engage in a particular, for instance, targeted acquisition or, if you know of an impeding terrorist attack or there's some law enforcement operation that requires support from military forces, okay? I'm not to say that those would never constitute a crime of aggression, but unlikely.
Unlikely.
Okay? We are talking at, when we look at the character, gravity, and scale, what that might be. There is near universal, to the extent you ever can get an agreement in the international system, that wherever the line of crime of aggression is, Russia's actions in February 2022 stepped across that line.
Yes. Perhaps not in 2014, though.
Yes, that is very true. There was back then you didn't have what you had in 2022, which is 140 states condemning Russia's actions, right? So this is where we get to whatever happened in 2014, by 2022, that action crossed wherever that line is drawn. I will say, people will point out, does international law matter? Does all this matter if we don't have enforcement, blah, blah, blah. One of the things that I think shows that the importance of why we still care about these rules is as Russia was then engaging in what it called the police action, right?
Right. The special military operation.
Special military operation. It grounded that in international law.
It did.
It said, we are doing this because we say, amongst other things, Ukraine is violating the Genocide Convention with regard to its actions against ethnic Russians and Russian nationals in its territory, right? So even though there is this agreement that Russia's actions violated whatever this crime of aggression may be, Russia did that saying, we're not, like they basically took the pains to put a legal justification on what they were doing to avoid being called that they were doing a crime of aggression.
My understanding is, and my reading of it is that Putin basically tried to use the exact same terminology as was used to justify the NATO military operation over Kosovo, so that he could both as a gesture and basically daring people to say that if this argument isn't good now, then it wasn't good then.
Yes.
I mean, yes. I think about if hypocrisy is the tribute that vice pays to virtue, the Russians paid a great deal of tribute to the idea of international law in 2022.
We see this in recent efforts as well and actions by states. So Iran using certain kinds of air weapons, missiles and whatnot, they were very clear that they were doing this on the grounds of self-defense, yes. right? They are framing this within international law standards and norms.
Yes, yes. Well, and I'm going to ask you an unfair question, but I'm curious, right? Does the existence of international law in this kind of format, does it make it more difficult for states to stop military operations? Because if they stop fighting, they then are open to prosecution, which they would not be if they continue to fight. I'm thinking about this, right? Is the complexity of, like, I go out of my way to say that I'm following international law. I don't want to end up in The Hague. Mm-hmm. And so therefore, I'm not going to stop fighting. I'm certainly not going to surrender. And so I think about this, maybe with Vladimir Putin, it's not as good an example, but with, say, a warlord in some place, right? Why would I ever want to, because it's not just a matter of I can stop fighting and negotiate some kind of compromise peace because I'm going to get hauled in front of The Hague. I don't want to get hauled in front of The Hague, so I'm going to keep fighting until total victory or until I'm dead.
That's a very interesting question. So I should have said the ICC, by the way, also in The Hague.
Also in The Hague, yeah, that's right. Thank
Many
you.
of
That's
these
right.
things in The Hague. So yeah, I mean, there are most certainly some leaders who want to hold their positions of power, whether they are formal government roles or you mentioned a warlord, right? Because there is this fear that when it's over, that there will be some accountability for what has been done. But I would say that's the case not just for something as severe as war crimes or these sorts of grave breaches we're talking about. That happens domestically.
Mm-hmm. True.
I mean, watch Breaking Bad, right? When we think of just even the criminal context, but in all seriousness, right? There is that push and pull, that tug. There are people, depending on where crimes are committed, the individuals might make the calculation, do I want to end up before an international tribunal or a domestic one? Mm-hmm. And for some individuals, they would rather be before the international one. The prison in The Hague is pretty cushy compared to what they might find if in a domestic scenario.
I was thinking to a prison in Monrovia or a prison in
who knows?
Kigali.
But certainly in many other places, there is a very formalized due process in the trials before the ICC. It is under the finest of microscopes from the international community, right? There are certain safeguards in those proceedings that if one were a criminal and your choices were, domestic or international, you might want the international option. But is that something that individuals think about? Probably. But it goes both ways because it also means that they may be thinking about it before they make their choices. And again, in making choices, trying to figure out how to phrase it in international law. I mean, there's lots of talk about international law being handcuffs for military operators, right? All of this sorts of thing, that the use of law just hinders the creativity, the whatnot of military operations. It is both an enabler and a limiter, okay? Mm-hmm. Limitations, though, can breed creativity. Enabling, yes, as much as there are provisions of what you cannot do, in saying what you cannot do, it's also then implying what you can do. Because all of this is based on the fact that war is going to happen. Conflict will happen. As horrible as that is to say, it will happen. Some of it will be interstate. Some of it will be internal. Okay, there will be times of formal armed conflict, informal armed conflict, all of these different things, but there can be rules. And so let's make some rules and hopefully bring a small bit of order and particularly an opportunity for accountability to the chaos that is conflict.
I have to say that is both a practical and a hopeful thought, and I think that's probably a good thought, at least for this conversation, to bring to a close. I'm sure we will have you back to talk about some of these issues again. But for today, Professor Alexandra Meise, thank you for joining us on A Better Peace to talk about the law of armed conflict.
It has been my pleasure. Thank you for having me.
And thanks to all of you for listening in. Please take a moment to let us know what you think about this program and all the programs. We're always interested in hearing from you. Please, and there should be no conflict about this, you should take a moment and subscribe to A Better Peace on your podcatcher of choice, because after all, why wouldn't you want to subscribe to A Better Peace so that you can hear more conversations like this one? And after you have subscribed, please take a moment to rate and review this podcast, because that's how more people can find out about us too. And we're always interested in growing the community. And so while this conversation is over, we look forward to welcoming you next time. And so until next time, from the War Room, I'm Ron Granieri.
And that concludes our program. Thank you for listening. The views expressed in this podcast reflect those of the speakers and do not necessarily reflect the views, policies, or positions of the U.S. Army or the Department of Defense. Let us know what you think. Provide us your feedback, comments, or suggestions through our webpage at warroom.armywarcollege.edu. And have a great day.